Ty Thomas. House. He's got the yellows.
All right, I believe we're ready to begin our afternoon court calendar. We'll do that by calling the case of the state of Wisconsin versus Ty Thomas. It's case 26 CF 1066. Appearances, please.
Jack Schneider for the state of Wisconsin.
Ty Thomas appears in person in custody with attorney Joe Frank.
All right, good afternoon. You should have a copy of the criminal complaint, Attorney Frank.
Yes, we do, Judge. We acknowledge it. Way formal reading. The personal information and address are all correct.
All right, thank you very much. And should we list you as counsel of record?
Yes, please. Thank you.
Very good. Does the state have a position regarding bail?
Thank you, Your Honor. The state is requesting $1,000 cash bail with a non-monetary condition that Mr. Thomas not operate a motor vehicle. It's alleged here that Mr. Thomas was traveling at a high rate of speed, approximately 60 miles an hour in a 25-mile-per-hour zone. When officers attempted to stop his vehicle, it's alleged that he increased his speeds, changing lanes rapidly, and which caused other vehicles to brake to avoid a collision with Mr. Thomas before running a red light. So from the state's perspective, given the evasiveness that Mr. Thomas is alleged to have been a part of here to avoid contact with law enforcement, I do think some cash is appropriate.
And Attorney Frank.
Thank you, Your Honor. We don't think cash is really appropriate here. First of all, looking at the public safety assessment, doesn't look like the failure to appear scale or new criminal activity scale is very high here. We haven't heard any record about any prior criminal convictions. I see no record of any bail jumping or missed court. The primary consideration here is whether he's going to make his court appearances. He's local, so he lives in Sun Prairie. He lives with his mother. He also resides with a brother and grandfather. He's employed online, so his family and job are all here locally. I don't think he'll have a problem making it to court. He also has a valid driver's license. He doesn't just use that for himself. So his mom's disabled. She can't get anywhere without Mr. Thomas's help. I really don't think that cash is appropriate here. And I would also ask that any conditions regarding driving would just require him to have a valid driver's license.
And did you say that he's employed online?
Yes, yeah, he's part of the gig economy, so any money he makes, he works online for it.
I see.
Yeah.
Okay, and I was just putting that together with the
Right.
statement about he's employed locally, because an online job presumably could be anywhere.
Yeah,
Yeah.
I'd agree with that, Judge.
Yeah. Any response from the state?
No, thank you.
All right. The public safety assessment report is certainly favorable to Mr. Thomas. All of the factors listed there are in his favor, and it recommends a signature bond. At the same time, the nature of the charge itself is an eluding offense. If I'm reading the complaint correctly, might be probable cause for two separate acts of eluding in this complaint as well. There looks like there's an allegation of him taking off from two different officers at different times in a short time period. The best measure, I think, of whether somebody's likely to appear in court is their reaction right there on the side of the road when an officer turns on their red and blue lights. And when that happens and the person doesn't stop, it causes me concern about likelihood of appearance in court as well. For that reason, I'm going to set cash bail at $1,000. I am going to grant the state's request for no driving. I am doing that based on the nature of the charge itself and the dangers associated with that. But separately, the complaint in the last paragraph alleges that when asked to account for that driving behavior in terms of speeding, leaving, running lights, etc., he's said to have told the officer that that's just how he normally drives. So there's a danger aspect to that too. Do you want a prelim within the next 10 days?
Yes, Your Honor.
Okay, we'll get that scheduled right away. That's fine. Mr. Thomas, if you're able to post that, you'll be released. You'll have another court date and that's fine. If not, you and your lawyer can talk about how to ask a judge to look again at the bail. Good luck to you. Take care.
All right.
Thank you.
Next question. Next is Michael Fortney, appearing via Zoom.
All right, I think we're ready to call the cases entitled The State versus Michael Fortney. Cases 24 CF 2186, 25 CF 446, 25 CF 972, 25 CF 1438, and 26 CF 1061. Appearances, please.
Jack Schneider for the state of Wisconsin.
Mr. Michael Fortney appears via Zoom video teleconference from the Dane County Jail alongside with counsel Skylar Boggio from the Public Defender's Office. I have present in the courtroom. I've received a copy of Mr. Fortney's complaints. I do waive their formal reading and I reserve objections for a later court date. appears that the address on each of the complaints are the same. Mr. Fortney is the 1213 Blaine Drive address. Is that a correct address for your mailing address?
Say 1213 Blaine Drive.
Yes.
Yeah, that can work.
I believe that was a yes, so I'll note the address is correct for a mailing address. I have indicated to me that he is eligible for the services of the public defender's office. I'd ask the court to enter not guilty pleas to each of the misdemeanor counts in the complaints.
All right, yeah, we'll certainly do that as to any misdemeanor counts in 26 CF 1061. I believe the other cases are here for bail hearings. It appears that when he was arrested on the new charges, pretrial services violation reports were issued. Commissioner Osmus directed that a warrant be issued, but that we address bail here on those cases, and we will. Maybe we'll start with the state for its position on bail.
Thank you, Your Honor. In all of the cases that we're here on a bail hearing for, the state is requesting $1,000 cash bail. And in the new matter, the 26 CF case, the state is requesting $2,000 cash bail. It does appear as though Mr. Fortney has picked up a slew of cases over the last 2 years. It looks like he was on pretrial services for GPS and alcohol monitoring. There was a bail hearing, I believe, on June 12th of 2025 in Branch 8 for most of those cases, where it was alleged that Mr. Fortney had damaged, I believe, the GPS monitoring as well as the alcohol monitoring equipment, had to be sent out for repairs. The court then set cash bail at the amount of $250 in all of the pending cases. At that point, his competency was then raised. And then on March 17th of 2026, Mr. Fortney was found competent. Judge amended all of the cash bail to a signature bond on March 17th of 2026, kept pretrial services in place for GPS monitoring. And then we have the new case, the 26 CF matter, that is now charged. So there was cash bail in place, from my understanding, on all of the felony cases prior to March 17th, when Mr. Fortney was given the benefit of the doubt on a signature bond in the community. He now has picked up another violent case where it's alleged essentially a unprovoked attack on another individual at the Beacon. He failed to appear, it looks like, on May 28th of 2025, as well as October 3rd of 2024. So when he wasn't in custody, he does not have a great history of showing up to court. So when looking at the number of cases that are open at this point, when looking at the chance he was given on a signature bond and he picks up a new case, I do think that cash bail is appropriate here. So I would ask for that total of $6,000, Your Honor. And in the new matter, I would ask that he be banned from the Beacon, as well as having no contact with Aaron. That's AARON, last initial B as in boy.
Okay, thank you. Mr. Boggio.
I just want to try to square one thing up. So I'm in receipt of the PSA. It says he's got a failure to appear scale of 2 low. I'll note that also the release recommendation is a signature bond on that, but it appears that he has no failures to appear. What was the one that
And maybe I missed it, but I don't recall hearing about a failure to appear.
I thought?
I mentioned May 28th of 2025. Could have been
I see a May 21st, 2025 warrant issued in one of the cases, though I think that was
a
a
pre-drop.
result of a violation. I don't know that it was a missed court appearance, but there certainly are a lot of cases. I have not looked through each one to confirm those dates. Sorry, Mr. Bush.
No, it's okay. That was, I guess that was the point I was trying to make, is that he doesn't have, at least not that I'm aware of, and the PSA, and I do think there was a warrant for the violation, but then he's subsequently appeared. So in these cases, I also just wanted to confirm that okay. So Going to start out with the appearance record. It seems that, Mr. Fortney with these cases does appear in court. He has, yeah, it sounds like there may have been some problems with pretrial services, but it also appears that he's been restored to competency in the meantime. I certainly think that's a change in factor that, I'd like the court to consider, favorably for him. Now, he has Attorney Schluter on his cases, and there is a new case here, which I think accounts for the new criminal activity scale on the PSA. And I think that does allow for the court to, consider the protection of the community aspect of it. However, the batteries appear to be misdemeanor in nature. And he does have an address here in the area. He was previously employed at a sandwich shop here in Madison. His parents and extended family live in the area. And I would ask that the court order a bond consistent with the evidence-based assessment tool that we have here. Certainly the restored to competency thing, I think does put him in a situation where he is more likely to appear in court. And if it wasn't for the bail jumping charges, it looks like most of the behavior is misdemeanor or allegations are misdemeanor in nature. So I'd ask the court to do a signature bond for each of these cases.
So I wasn't able to locate that specific missed court appearance that was described by the state earlier. In trying to look through the court record in the various cases, I do see a failure to appear on September 19, 2024 in case 24 CF 2186. There was a joint request to not issue a warrant and give him an opportunity at picking up a notice in hand for another prelim the following week. Then the record reflects that a warrant was issued on October 3rd of 2024.
That was 24 CF what? I'm sorry.
2186.
Got it. Okay, thank you.
And because that's sort of newly discovered information, I wanted to share that so everybody has an opportunity to respond to it. Similarly, and again, there's a lot to look through, but as I'm looking through it, if I'm not mistaken, I think there's been over the course of these cases exactly one court appearance that he's made where he was not in custody. And that would have been last week on May 8th.
Well, and it looks like he was deemed incompetent. I mean, I can't tell if that's the 6 or the 9 month review, but for certainly a long period of time. Yeah, so it looks like the 6 month evaluation. So he was in for over 6 months at that time. I don't know what the state's looking at for an offer, but it certainly looks like he would have a substantial amount of credit.
Well, and to that end, the court record also reflects that the case is scheduled for a plea and sentencing hearing on June 26th. It looks like that may have been scheduled a day or so before the new arrest.
I see that now.
Anything else from the state?
No, Your Honor.
Okay, give me just a moment to look a little more carefully at a couple of things.
You can't grant me another signature bond at this point?
Well, I don't know that it would be just once, but I appreciate the request. All right, thank you. I have had an opportunity to look at the court record, of course, heard the arguments that have been presented here today. Mr. Fortney is on his 5th pending case. As noted earlier, he does have a now dated failure to appear history in one of the cases. By dated, meaning a little less than 2 years ago. Of course, that it's some time ago is made less significant by the fact that it remains a pending case because of all of the subsequently obtained matter. I think we're just at a point where enough's enough in terms of low cash bails. There's no real reason to think that the results are going to be different if he's released on a signature bond, if there's another attempt at pretrial services. And at this point, I'm persuaded that substantial cash bail is necessary to assure his appearance in court. I differ a little bit, I think, with the state in terms of the number, and I might allocate it a little differently. I should do some quick math here to figure out how best to do that. Three of the cases are Act 3 eligible offenses. They're in some respects bookends of this because it includes the first one, case 24 CF 2186. It includes one in the middle at 25 CF 1438, and then the most recent 26 CF 1061. I'll set cash bail at $1,500 on each of those three cases. I will set cash bail at $300 on the remaining two cases. I know those are fairly different bail amounts. I'm trying to differentiate the ones that are Act 3 eligible and assaultive in nature versus the ones that don't meet that criteria. And it gets us to a total that I think is somewhat less than what the state proposed, but is still what's necessary and appropriate. I will continue the previously imposed conditions in the older cases, except the requirement to participate in pretrial services. We're talking about pretty substantial bail. If he posts that, I think that increases the odds that he'll comply without the need for pretrial services. It also doesn't appear that that has been particularly effective to prevent new violations. In the new case, I'll set the condition that he not be at or around the beacon, and also that he have no contact with Aaron B. I believe that only the newest case is pre-prelim, but let me confirm.
That does not appear to be accurate. 25 CF 1438 does not seem to have gone through preliminary hearing yet. Time limits do not appear to have been waived, as you noted, in a schedule for sentencing.
Huh, well, maybe for the sake of making sure everyone's rights are protected fully, we ought to schedule that case and the newest case for a prelim right away.
Yes, please. And we just ask that time limits remain in place for those.
Yeah, we'll do that. We'll certainly get that set within the statutory time limit. I assume that there had been a thought about waiver of the prelim, as part of the plea and sentencing process, but since we don't know what's going to happen with any of this at this point, let's make sure he's protected by having a timely prelim.
And it looks like Attorney Schluter will be appointed to it, and so that shouldn't be an issue for our office.
Okay, good to hear. And good luck to you, Mr. Fortney. Take care.
Next is Bryson Zients, hearing via Zoom.
All right, I think we're ready to call the case of the state of Wisconsin versus Bryson Zients, case 26 CF 652. Appearances, please.
Jack Schneider for the state.
Mr. Zietz appears in custody from the Dane County Jail. Attorney Merle Josty appears on his behalf here in the courtroom.
All right, yes, thank you. He is appearing via Zoom. Mr. Zietz, I just want to confirm that you can hear us okay.
Yes, sir.
Okay, thank you very much. I know that Mr. Zietz does have open cases in Dane and Greene counties. I assume the clerk is going to automatically schedule this to the right judge.
That looks like that would be good.
Okay, thank you for that. Mr. Josty, I don't know if I asked whether you've received a copy of the complaint and have any address updates other than the jail.
We have a copy of the complaint. His present address is the Dane County Jail, but the address on the complaint is fine. That's the family residence.
Understood. Thank you. Does the state have a position regarding bail?
Yes, Your Honor. State's requesting $2,000 cash bail for Mr. Zietz. Mr. Zietz he's currently facing a first-degree sex assault, sexual contact, or sexual intercourse with a person under the age of 13. That's in Greene County. I believe he's sitting on $10,000 cash bail in that matter. He has a pending flee and elude in Dane County that he was on bail for, I believe, a signature bond at the time of this offense. So from the state's perspective, given the open pending cases that he does have. The allegations that he's bringing a facsimile firearm to a school and threatening individuals with it certainly concerns the state, but also given the bail risk of doing this while on bail in multiple serious felonies in the first place. The state does believe that cash bail is appropriate. I would request the condition that he not use or possess any dangerous weapons or facsimile firearms.
Thank you, Mr. Johnston.
You'd ask for a signature bond in this case. As the DA has alluded to, Mr. Zietz is sitting on a cash bail in Greene County of $10,000 that's not been posted. He's been in custody there almost 2 months. Just a few points of correction. Obviously, there's a basis for the felony bail jumping here, as he had been released on the original fleeing case. The Greene County matters, though, occurred after the date of the allegations in this matter. This case obviously has taken about 3 months to get charged and have an initial appearance. In terms of the conduct that's alleged here, Mr. Zietz has already graduated from high school, so there's no need for him to be on the campus there any further in the future. I would suggest that you give him a signature bond with the prohibition of the use or operation of any real or facsimile firearms, and also a prohibition of being on the high school campus. I think that would address the court's safety concerns. And as I indicated, he's already sitting on a significant cash bail. I don't think sending another cash bail here really serves any purpose.
Thank you. And any response from the state?
No, thank you.
I'm just taking a closer look at the complaint. I think both counsel make good arguments here in terms of the chronology of events and all of what Mr. Zietz has going on. All of what he has going on issue is probably the most concerning to me because he has so many pending felony cases now. Some of them are serious. It's true that he's in custody on a substantial cash bail on one of those, and that charge is the most serious of the ones that he faces. I also recognize that what's alleged in this complaint is said to have occurred before those other behaviors that are alleged in Greene County. It's not as though he was out on a bail out of the Greene County cases and picked this up. He was allegedly on bail for an offense that tends to cause one to be concerned about likelihood of appearance in court, however, namely the underlying eluding case. I think we're at a point where some cash bail is appropriate. I don't think it has to be a substantial cash bail on this case with these charges allegedly occurring 4 months ago. Probably his release status is going to mostly hinge on what happens in Greene County more than what it is here. But I don't think a straight signature bond would be appropriate here. I'll set cash bail at $500. I'll order as conditions that he not go armed with dangerous weapons or possess any facsimile firearms. I'll order that he not be on the campus of Middleton High School. I think that's the request. I think that meets the essentially joint request as to that point. If I got the wording of that wrong, please feel free to correct me.
That works for the state.
And I think that was your proposal for wording, Mr. Johnston.
That's fine.
Yeah, I think that's appropriate. Let's get a not guilty plea entered on the misdemeanor charges. I guess there's also a forfeiture. We'll get a not guilty plea entered on. Do you want a prelim within 20 days?
We can waive time limits.
Sounds great. And Mr. Zietz, good luck to you. I hope things work out.
I guess I have one more question for Attorney John. For the status conference that we're scheduling, would you like a writ prepared and have your client brought back here, or should it be forego that?
It's very likely. I'm meeting with him tomorrow. Bryson, I'll be out there tomorrow morning to see you. That will be doing the prelim waiver form and handle the case that way.
If you would like to have a prelim, they can certainly have a written back for that 20, everybody's aware.
Sure.
I'll omit that in the text so that the DA's office is not prepared or written and have it brought back unnecessarily.
I think that makes sense.
Okay, appreciate that. I assume, Mr. Josti, you're aware of his initial appearance tomorrow in Greene County.
That's why I'll be there.
Makes sense. Just wanted to make sure that, I know sometimes not all the information gets passed. I want to make sure everybody's aware.
Thank you.
All right, well, good luck to you, sir. Take care.
Next is Maria Alonso.
Are we picking a date now?
I scheduled it for June 22nd, 2/20.
June 22nd at 2:20. Thank you.
Okay, we'll call the case of the state of Wisconsin versus Maria Rangel Villalbazo, case 26 CM 1069. Appearances, please.
Jack Schneider for the state.
Porque va a dar condiciones de una fianza prohibiendo que usted esté en ese lugar.
En ese lugar yo vivo.
I live in that place.
Okay. Con mis cuatritos en el.
4 children in the basement. Las personas no pueden estar tanto Fernando Padilla, Alexis Padilla o José Ángel.
Por la razón porque no es mi hijo, ahí es mi hijo, ya son adultos y son mis hijos, así que tienen la novia, no, va a ser mi hermano, pero no sé por qué.
Can you tell me the reason for that? Because those are my own children and that's my brother. So, porque sabe que son víctimas de casos suyos. Víctimas o fans. Es un otro caso. Yo no sé por ahí se dice pero entiende que está fianza de libertad en otro caso.
No,
Claro, verdad.
lo que pasa es que mi hermano está haciendo videos virales de todo tipo y su hijo tiene entonces él también me ha echado humo también y me ha hecho así vomitar también sangre y usado
Usted sabe que tiene que cumplir con las órdenes de la corte, no puede tener contacto con esas personas.
okay.
I wonder if we should swear the interpreter.
Thank you.
Mr. Swenson, do you swear or affirm that the testimony you provide will be the truth, the whole truth? I'm sorry, do you swear that you will truthfully and accurately interpret the proceedings?
Yes, I do.
All right, started to administer the wrong oath there. My
Okay.
apologies.
And also I can make my appearance. Sorry, Commissioner.
So, I'm sorry,
Pasa que mi hermano Luis,
Don't say anything to the court right now.
okay, pero él
Okay.
está haciendo virales YouTube videos.
No,
Él
he's
hizo-
making
él
viral
hizo-
YouTube videos.
él hizo una cara, nomás le causó un rasgo, pero él me echó
We're not gonna talk about the case right now.
un ataque cardíaco, que fallé, me dio un ataque
Maria, we're not gonna talk about the case right now.
Okay, nada más que lo que dice está mal, porque ellos no son
Well,
víctimas.
that here is
están
wrong.
haciendo-
They're not
están
victims,
haciendo
they're just making it up, they're
no
just
son-
making viral videos.
Ms. Maria Rangel Villalbazo appears in person and in custody alongside counsel Skylar Boggio. I have received a copy of the complaint. I waive its formal reading and reserve objections for a later court date. I have confirmed that the address is proper for the time being, although we may have to update that after this hearing. Ms. Rangel Villalbazo is eligible for the services of the Public Defender's Office and has been appointed Attorney Sheehan in her other case. I'd ask the court to enter not guilty pleas to both counts in the complaint.
We'll do that and we'll get the case assigned to Judge McNamara for trial proceedings. The other two cases are assigned to that judge. Also relevant is that yesterday, the judge granted defense counsel's request for a competency evaluation in those two other cases. It, unless somebody has something really persuasive to add about that, I would think we should add this case to that referral, just so that it can all be assessed at the same time. That said, our local court rule says that we're supposed to also address bail at this proceeding. Does the state have a position regarding that?
Thank you, Your Honor. The state is requesting $1,500 cash bail, as well as the non-monetary conditions that the defendant not have contact with Alexis, Alexis, last initial P, or Jose, last initial R. So Miss Rangel Villalbazo is facing two open cases. Both, well, let me back up. The first case, 24 CM 1565, was given a signature bond with the non-monetary conditions to direct no acts or threats of violence. She's then charged in a battery in 26 CM 433. It looks as though a signature bond was set on May 11th of 2026. This was after, I believe, what looks like a speedy trial demand was requested, so she's released on that signature bond. But Miss Rangel Villalbazo has multiple warrants issued for non-appearance. September 4th of 2024 was in warrant status for approximately 6 months. And then October 3rd of 2025 was in warrant status for approximately 4 months until February 22nd of this year. So given that she was released on a signature bond on May 11th and then immediately was alleged again to violate bail by having contact with these individuals, I think cash bail is appropriate.
Mr. Boggio?
Sure. So it looks like she was released on a signature bond, not even, it wasn't really by choice. It looks like it was, she was held in for 60 days in custody. I would assume that based on that attorney, she hadn't had a speedy trial demand, because it mentions in the notes about the 60-day rule requirement. So she does receive SSI, she does receive food stamps and is on Badger Care. So I think any amount of money is going to be at least significant, if not impossible, for her to reach. And if she was held in custody for 60 days on cash bond before, I think that it's unlikely that she has money to post bond. She's been in Dane County for 18 years. Her parents, children, friends are in the Dane County area. It looks like when she was released, she's alleged to have basically gone to her last known address or her home, which I've tried to explain to her that she is not allowed to have any contact with the alleged victims in her cases. But these are not Act 3 eligible offenses. So I would ask the court to either do a signature bond or a low amount of cash bond, as I think any amount may hold her for a significant period of time. I also have no objection to the court ordering a competency evaluation, as that would be consistent with the other cases.
Anything else from the state?
No, Your Honor.
The court record in the earlier cases is consistent with what's been described here on the record. Though in addition to that, it should be noted that there is a history of her posting cash bail in at least one of those two cases. That's case 24 CM 1565. There's failure to appear in that case. And in fact, when the bond was modified a couple of days ago, it actually resulted in the refund of some bond that had been previously posted. It's, I don't know whether that was intentional or not, but that is the end result, which means that some money is likely coming her way, though perhaps by mail. I can tell, looking at the court record in those cases, that a combined bail of $800 resulted in her spending some time in custody and not being able to be released. I do take that into account, figuring out what number is appropriate here. To be clear, we are talking about a number. There's just no way that release on a signature bond would be appropriate at this point. She's out on bond on 2 separate Act 3 eligible battery cases with additional charges included. It's alleged that when released from jail, she violated her bond conditions within 40 minutes. I doubt that's a record, but it has to be very close. The least amount I'd be willing to set at this point is $1,000. I do think that recognizing her prior custody status on a bail a little less than that is appropriate, and is why I would not go as high as what the state is proposing at this point. I also just don't think this is a situation where a proper response, or one that is consistent with the interests of appearance in court, treating court orders and requirements seriously, and the protection of the public, would support release on something less. So I'll set $1,000 cash bail. I'll reiterate the condition that she not have contact with Alexis P. And I'll make a finding that there's reason to doubt competence based on the request of trial counsel in the earlier 2 cases from just a couple of days ago. The clerk indicates that I forgot to order the no contact with Jose R.
Sorry, contact with.
Jose R. I think that's appropriate, given what's alleged in the complaint. Let's call that an outpatient competency evaluation at this point to match the ones entered by Judge McNamara. And then we'll get this scheduled for a return date in front of the judge at the same time as her other cases. Good luck to you, Ms. Ronald.
Next is Gianna Smith.
I'm sorry, who?
Smith.
I have 2 more cases. I have 2:30, so I gotta either go and come back.
Yeah, we'll need to get the interpreters.
Sounds like we're working through
We
that.
would have been able to take care of Henry Watts cases earlier, if the interpreter wasn't here.
I think they made a switch and we're calling a couple of other cases.
Okay.
Sorry about that.
Next is Felipe Pacom, anyway.
Felipe, Hassan, Mane,
Okay, let's call the cases of the state of Wisconsin versus Felipe Acham Angue, cases 25 CM 1068 and 26 CT 363. Appearances, please.
Jack Schneider for the state.
Mr. Felipe Hacham Angue. Pardon. Appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of both complaints, waive their formal reading, and reserve objections for a later court date. The correct address.
Yes, that's what it is.
Mr. Hacham Ange appears, or excuse me, does indicate to me that the address is correct on the complaint. I have indicated to me that he is not eligible for the services of the Public Defender's Office. However, he has been appointed attorney Anthony Jurek in the past. I think he'll need to reapply on the new case as well. I'd ask the court to enter not guilty pleas to each of the misdemeanor counts in the complaints.
Yeah, he does have that open case that's assigned to Judge Highland.
One more.
That's what we're gonna try to do now.
Los otros casos están asignados al juez Jairo.
And also certified interpreter Fred Svensson is here and he was previously sworn. Mr. Atom?
Hashem.
Hashem.
Yes, sir.
All right, thank you. It looks like you used the county appointment process to get Mr. Urick assigned to your case. If you follow that same process in these two new cases, it's likely that they'll appoint him on these as well. What's the state's position regarding bail?
Your Honor, in both matters, the state would request a signature bond with a non-monetary condition that the defendant not operate a motor vehicle. Does look like he now has 3 OARs pending, all from 2026. Does not hold a valid driver's license. So from the state's perspective, he should not be operating a motor vehicle.
I have no objection to either the signature bond or the non-monetary condition. Typically, I would ask for no driving without a valid license, but I think at this point, I won't, he's fine with me not objecting to the state's request for no driving period. I'll also note that this is consistent with the evidence-based assessment for the public safety assessment, showing no failures to appear at all.
I guess this is gonna sound like a facetious question. It's not intended that way entirely. What's likely to be different this time if he's released on a signature bond versus the first time?
First, basically, I don't want my family to really just no say this is I'm speaking to look at this. No, I don't get it. So that is gonna be my last time in here.
1 second. Thank you. Let me ask 1 second. Well, 2 things. First of all, based on what he just said, I think he's a lot more scared realizing that these cases pile up. So that would be from Mr. Hachem Angu's perspective. For my perspective, I'm just looking at this without a failure to appear in court. I don't believe these are Act 3 eligible offenses. I certainly understand the court could consider the fact that a person not following court orders may make them less likely to appear in court. But I guess the proof or track record that we have doesn't include missed court appearances. And I would ask that the court weigh that heavily in deciding whether or not cash bond is required in order for him to make his appearance in court. The other thing too is if he does actually do the work to get his license back, I think he would be highly incentivized to appear in court, as these cases are oftentimes used as a carrot or incentive for a person to get their license back here in Dane County.
Any response from the state?
There, Your Honor.
Obviously, I'd have to be a little concerned about whether he's going to follow the conditions of bond. Because he signed a signature bond promising not to drive without a valid license back in March. We, from these 2 complaints, have, well, one of the complaints says that he was allegedly caught driving in the early morning hours yesterday or on Tuesday evening. There is a driving record attached to that indicates that he's, if I'm reading it correctly, that he's never had a Wisconsin license. Is revoked for OWI and has been stopped on at least a couple of occasions since then, other than the ones that we're talking about here today. In fairness to the defendant, one of the cases in front of us today precedes when he was placed on bond. So that wouldn't be a bail violation. It was before the stakes got escalated that way. I also recognize that, to my knowledge, he doesn't have a history of missing court, and I don't know that there's reason to think he would have been incarcerated in response to any of these other events before now. There's probably something to be said for the idea that he's sat here in jail for the last 36 hours or so and has hopefully concluded that that's not what he wants to do going forward. I don't want that either. I don't want him sitting in jail. I don't want anybody sitting in jail, and particularly for misdemeanor driving charges. But that future is something he can see as a result of what's happened for the last couple of days if he chooses to go and violate these bail conditions. I'll go along with the joint request for a signature bond in the two cases that are in front of us today. In both cases, I am going to have the condition be the strict condition that he not operate a motor vehicle. Mr. Boggio is right that these are relatively minor charges, and they're the sort of charges that can resolve favorably to you if you make your court dates and don't keep picking up charges. I don't want to see this snowball or get worse beyond what it has so far. It's just not worth it for anyone. Let's get a not guilty plea entered on your behalf, sir, and we're going to get you another court date. We'll have that match the court date you already have in front of Judge Hyland in the other cases. Good luck to you. I hope things work out.
Next is Dennis Cruz and Sarah.
Dennis Cruz Serna.
Yeah.
I don't think I do.
It's a forfeiture.
Oh, that explains it. Thank you.
All right, let's call the case of Dane County versus Denise Cruz Serna, case 26 FO 821. Certified interpreter Fred Svensson is here and was previously sworn. It appears that Mr. Cruz Serna was taken into custody on a variety of charges. The DA has charged county ordinance violations instead of criminal charges. The complaint that you have there is essentially like getting two non-criminal tickets. One is for obstructing or resisting an officer. The other is for possession of THC. You could enter a not guilty plea on those charges. If you do, you'll be released without a bond on this. You'll just have other court dates here in Dane County on them. That would keep open all your rights, including potentially a trial on these if you wanted that. The state or the county likely has some sort of an offer to resolve the cases here today too, if you want to hear that.
Yes, that's fine.
It would be $1 plus court costs on count two. The state would dismiss count one.
So if you took that offer, sounds like the county's agreement would be that you'd pay $138.76 on the THC charge, and they would dismiss entirely this non-criminal violation for resisting or obstructing an office. You would, just to be clear, if you took that, you'd be done here in Dane County. You still would have to deal with any court dates you have up in Sheboygan County. I say that because I know that you do have a pending case there as well.
But when would I have to pay them?
We'd get you 60 days, or you could ask for an extension with the clerk of courts if you needed it.
That's fine.
Okay, I'll take that as a no contest plea to the possession of THC charge, dismissing the more serious resisting or obstructing an officer charge on motion of the county. The total will be $138.76. It does appear that when he was taken into custody, federal immigration authorities asked for a detainer That's not being honored by the jail due to the sheriff's policy on that. So I don't think that will hold you in custody. I think you'll be able to be released here today. Please still pay attention to your court date up in Sheboygan. Good luck to you. Take care.
Thanks, Fred. Thank you.
Now, hopefully, we're ready for Ms. Smith.
No. Next is Gianna Smith. Ms. Smith, you stand up and go.
All right, let's call the case of the state of Wisconsin versus Gianna Denise Smith, case 26 CF 845. Appearances, please.
Jack Schneider for the state.
Attorney Darrell Watts appears on behalf of Gianna Smith. At this time, I would move to dismiss this matter as I don't believe this court has the jurisdiction to hear this matter. Specifically due to the fact that in the criminal complaint, it alleges that incidents occurred in Minnesota, allegedly by Ms. Smith, and none of those actions occurred in the state of Wisconsin. So for those reasons, I would move to dismiss for lack of jurisdiction.
Sure, and we should talk about that for sure. I just wonder if we can get a good mailing address and I'm assuming you're waiving the reading of the complaint.
I mean, typically I like to get that out, the initial argument out first, and then of course, if, then.
Yeah, and I'm not asking you to waive the argument,
Okay.
be preserving it.
So I'll waive this formal reading for sure.
Oh, yeah, we can take up the address after if necessary, I suppose. We'll come to that. Well, take a look at the jurisdictional question. Unless the state was expecting that, maybe you need to take a moment or two to look to formulate a response.
I just need to double check the complaint here quick, Your Honor.
Sure. In fairness, I should probably just identify that by coincidence, this case was presented to me for complaint and warrant. So I did review the complaint and I made the decision to issue the warrant. I recall thinking about the issue that's being raised by defense counsel at the time, but it's been a month or more and obviously we should visit that issue anew at this point.
If I may, under 971.19 sub 11, in an action under 943 sub 201, the identity theft statute, the defendant may be tried in the county where the victim or intended victim resided at the time of this offense. It's my understanding that the alleged victim here was residing in Wanakee. So I do think the state has jurisdiction here.
Can you repeat the statutory reference?
It's 971.19 sub 11.
Okay. So, and that's the venue statute. I think maybe counsel's argument is a little different.
That's correct.
I think it relates to the jurisdiction of the state over
That's
over the
correct.
offense. I don't know if you want to speak more to that or if you want to hear from the state first on that point.
I think that's the exact argument, is that the state of Wisconsin does not have the jurisdiction over this matter.
And again, we'll give the state an opportunity to form any response.
I think I would just defer to the court, given the venue statute here, Your Honor. I don't see why the state would not have jurisdiction over this offense, given the location of the victim here.
Well, I think the relevant statute might be one of the subsections of 939.03, but I think we should explore that a little bit more carefully if there's argument either party wants to make regarding that.
Nothing from the state.
Okay, Mr. Watts.
Your Honor, I will keep my argument where it's set at this current moment.
Sure. Well, I think she's entitled to have me re-look at the complaint at this point. The issue is being raised in a non-ex parte fashion. I recognize that the initial call I made on that was viewing it in the absence of a motion necessarily and just looking at the bare form of the complaint. So give me just a second to take a closer look.
And just briefly, Your Honor, are you creating an argument for the state or are you just reviewing a statute? Because I don't believe the state cited that statute.
That's true. It didn't, but I think the issue you raise requires us to examine that because that is in the absence of anybody presenting any other law, that would seem to be the relevant statute. I have not yet reformed an opinion about whether it meets the elements of that. I haven't gotten that far in the analysis yet. I see this complaint as meeting the jurisdictional requirements of section 939.03 under actually at least 3 of the subsections. Might be 4. Let me take a closer look. Yeah, so there is, I think, always potentially the argument that in an identity theft case, one of the constituent elements is non-consent or the falsely representing oneself to be that other person or to have their authority. When the victim of that offense resides in the state of Wisconsin, it suggests that a constituent element takes place in the state of Wisconsin, even if somebody is without the state. That would meet sub 1 sub A. This complaint also has probable cause to believe that while out of the state, the defendant aided and abetted or conspired with, et cetera, others to commit a crime in the state of Wisconsin for really similar reasons. There's also probable cause to believe that while out of the state, she did an act with intent that it caused in this state a consequence set forth in a section defining a crime. That's sub 1 sub C. Loosely, I suppose that would be what I'll colloquially call the theft of the identity. And then lastly, there's the specific exception, or it's really not an exception, it's a provision in 1E that identifies identity theft charges specifically and indicates that it applies if the victim is an individual who resides in this state. That's a slightly different argument than the county-based venue argument that was cited by the state earlier. I don't see any argument at all with respect to venue in this county. I think the stronger argument is the jurisdictional one raised by the defense. But I see this complaint as sufficient to confer jurisdiction on any one of those theories. That's not determinative for the course of the case as a whole. Of course, at a trial or at some point later on, those things would have to be proven before she could be found guilty. But I think there's enough to essentially hold her to get this evaluated. And I don't mean that in the bail sense. I mean in the sense of having her be subjected to court proceedings here. It's an interesting question, I suppose, as to constitutionality of a long arm statute when the physical constituent acts are said to have taken place somewhere else. And I recognize that. That's just not an issue we're going to be able to reasonably resolve at this initial appearance. But so on that basis, I'm going to deny the motion at this point. Of course, that's without prejudice long term. Mr. Watts, should we turn to the address issue?
Just one more thing, Your Honor.
Sure.
Based on the denial of that motion, I will rebuff the motion to dismiss the charge associated with Ms. Smith based on the allegations or lack of allegations contained in the 4 corners of this document. According to the criminal complaint, there was an extensive investigation prior to charges being filed. There's 3 other co-defendants. According to the criminal complaint, they reviewed text messages displaying alleged intent by Ms. Dixon, videos, iCloud accounts, individuals residing at properties at issue, which would be Kinsey and the Sharp Mill. With Ms. Smith, this complaint merely just establishes that Ms. Smith knows Ms. Dixon. There was no allegations of There were no indication that Ms. Smith intended to obtain a value or benefit, nor that she received a value or benefit. Moreover, there was no indication that Ms. Smith had knowledge that the information was provided without authorization. It's just a mere paragraph in this complaint that states that she was informed to do something allegedly with this information, but all of the other elements of the alleged crime is devoid in this criminal complaint
All right.
as far as establishing probable cause.
I am going to deny that motion as well. I think that there's multiple sources of information in the complaint that support probable cause. Probably at its sharpest is the large paragraph that specifically relates to Ms. Smith on page 5 of the complaint, where it specifically alleges that she's in communication with these other individuals, that there are multiple stolen identities involved, that Ms. Smith specifically used this other person's personal identifying information to apply for a lease or for rental property. Certainly one reasonable inference is that if somebody is posing as somebody else for the purposes of obtaining rental property, that's done for fraudulent intent, whether that's to defraud the person whose identity is being used, or whether it's to defraud the landlord, or some combination of those things. So I appreciate the argument, but I think there's enough in this complaint to at least justify further proceedings. Again, separate question from whether it can be proven beyond a reasonable doubt once the details of some of these communications get evaluated, and I recognize that point.
Yeah, with that being said, Your Honor, again, we waive his formal reading. Ms. Smith is aware of the maximum penalties and consequences associated with the charge. And at this time, we request a preliminary hearing.
Sure, and let's turn to the state's position.
Sorry, I still didn't get that address.
2813 65th Ave North, Minneapolis, Minnesota, 55430.
That makes sense for the reasons sort of identified in the body of the complaint, and also because it looks like she was extradited from Scott County, Minnesota. What's the state's position on bail?
Thank you, Your Honor. The state is requesting $5,000 cash bail, as well as the non-monetary conditions that Ms. Smith have no contact with M as in Mary, N as in Nancy, M as in Mary, and that she not use or possess any financial documents or instruments not issued in her name. It is my understanding that Ms. Smith has no known ties to Dane County, obviously resides in the Twin Cities area, and has multiple prior convictions for theft-related crimes, both at the misdemeanor and felony level out of Minnesota. So given the allegations here, given the lack of local ties, and given her history, I do think significant cash bail is appropriate, especially since she was extradited from Minnesota.
Mr. Watts.
Your Honor, at this time, I would object to the cash bond, as well as I would like for it to be tailored for the non-monetary, because Ms. Smith has children. So to say to have no identification or documents of any other individual, I think it's fair to say if it's outside of her children or family. But otherwise, I will argue for a signature bond. Ms. Smith is 34 years old. She has a high school diploma. She has an associate's degree in health science. She has 2 children, which she's the sole provider for, a 14-year-old daughter, as well as an 8-year-old son. That's in 8th grade. Her daughter's in the 8th grade. Her son is in the 2nd grade. She's currently in college working towards her bachelor's degree. She has a driver's license, so it shows that she can get to and from court without issue. As far as work history, she's had gainful employment for the past 5 years. Currently and for the past 11 months, she works at Southdale OBGYN as a medical assistant. Prior to that, she was in school to obtain her esthetician license. That took 11 months. And prior to that, she worked at Children's Hospital as a health unit coordinator for 3 years prior to that. She has religious ties as well, as she's been a church member for over a year. And there's some significant health concerns. Her son has chronic asthma. Ms. Smith also suffered a traumatic brain injury as she was shot in her head approximately 10 to 12 years ago, and she sees a neurologist monthly. Currently, her dad, who would assist with the children's well-being, just had heart surgery and had additional fluid on his heart, and she's the caregiver for her father as well in that matter. But that is the individual who would typically help, and then with her being in custody, we will be setting things up for a catastrophic finish. Moreover, Your Honor, as stated, I can rebuff the arguments about the minimum amount of, the allegations of her liability in this matter, as there's only 1 paragraph out of 9 pages attributed to Ms. Smith, as well as the minimum involvement allegedly. Another thing, Your Honor, is that the co-defendant, or the alleged main culprit, Ms. Dixon, recently received a signature bond in this matter, and she has 3 felony charges contained in this complaint. So again, for those reasons, Your Honor, I will respectfully request a signature bond. It can be a high signature bond. Therefore, if Ms. Smith does, does not comply with bail, then she'll be back here today with a high cash bond.
And I don't see that we have a public safety assessment report on file in this case. That might be the result of the extradition and her having been in custody for a period of time prior to coming here. But I do want to confirm with Ms. Anderson, our pretrial assessor, that's the reason it's missing.
Yes. That's
Okay. Sorry, Ms. Anderson, I cut you off.
Sorry, yes, that's the reason.
Okay, thank you.
And just for clarity, Ms. Smith informed me that she's been in custody for 13 days. And I would also make note, Your Honor, that there's addresses for other individuals. And as you can see, there was no address for Ms. Smith. So it's not as if she received any notice of this and just avoided it. This case was filed without her knowledge.
Yes, I recognize this was initiated on a warrant. There wasn't a summons provided or anything like that. But let's see if the state has any response to the bail arguments.
Nothing to add, Your Honor.
Okay. Well, let me take a closer look. And I guess either I didn't hear it or I missed it. Any information of, oh, I'm sorry, you did mention there were some prior theft related charges. I'm just trying to figure out prior record. Okay, and no information that I heard about prior issues with making court appearances?
No, it's about clear as mud trying to find missed court appearances in Minnesota. From my perspective, Your Honor, I can just see those prior convictions.
I definitely take into account the fact that she didn't miss a court date here, that she didn't get served a summons and then blow it off or anything. I'm not speaking to the behavior that's alleged, but I'm assuming that the issuance of the warrant and her arrest was something of a surprise at that time period. And I recognize that. I also do recognize what's said about her having been in custody almost 2 weeks between Minnesota and Wisconsin. Also a fair point that she's alleged to be one of many people involved in what's said in the complaint. I don't have a strong reason to assess the relative culpabilities of the various parties at this point. But I'm not trying to take away from the point made by defense counsel about the fact that Ms. Smith's specific involvement appears to be summarized in essentially one paragraph of a very long complaint. If true, that's not an insignificant involvement, though. It's obviously concerted behavior with other individuals. I think the only reasonable inference that one could draw is that if these events occurred and she was involved in them, it was part of a broader conspiracy, that it was for profit making, essentially. It's not as though the most reasonable inference from this complaint is that it's some form of identity theft for the purposes of simply having a place to live. Not that I would find that to be legally acceptable either, but it would be different in feel, I think. And it would be different in terms of likelihood of being able to post cash bail and resources and the like. She has significant employment ties in Minnesota. That's a factor in her favor. Also suggests some ability to post bail. I think it is a relevant argument. I should phrase that in a way to make sure I'm clear about it. It is relevant that the co-defendant, Ms. Dixon, was granted a signature bond. One distinguishing feature is that it appears that Ms. Dixon showed up in Dane County Circuit Court and had an initial appearance. Must have learned about the complaint being filed and took those steps to specifically come before the court in order to get it addressed. The fact that Ms. Smith did not do that is not really something I hold against her for the reasons that were identified earlier, because she may not have been aware, but it also isn't the specific affirmative showing of good faith that Ms. Dixon obviously engaged in by showing up here. Reasonable minds can certainly disagree on what a reasonable bail in this situation is. I don't think there's anything particularly inappropriate about what the state requested, and one can make an argument that that's almost a cost of doing business if what's alleged in this complaint is correct. I also think a lesser amount is workable potentially. I'm going to set cash bail here at $3,500. I'll order as a condition that she not have contact with MNM. I think the point made by Mr. Watts about how to structure that financial instrument or document condition is a good one. Maybe I'm misunderstanding certain aspects of this complaint, but I don't know that it's specifically alleged that Ms. Smith had like a particular document or card or some sort of government issued thing in the name of the other person. I think we're talking about the sort of generic use of names and identities and things of that sort. And unless you have some better way to sort of draw the line on how to make that condition, I'm inclined just not to set it.
I would defer to the court. That seems reasonable.
I think we just won't set the condition about identifying documents. If she has children and things, there's certainly reasons to have access to that for those people. And again, given the specifics of what's described as her involvement, I don't know how necessary that condition is. Also, if it turns out she's running around with identifying cards for people that have no actual relationship to her, I suspect whether it's in Minnesota or Wisconsin, that would be actionable as a criminal law matter for reasons separate from any bail condition. So let's just not set it. Ms. Smith has the right to a prelim within the next 10 days, 10 days. Do you want to have that set right away?
Just 1 second.
Sure.
She'll waive time limits. And just one thing before the final, I don't know if the bill was final, is it possible to split the cash with the signature bond? It is some sort of cash on the table as well as an additional cash component if she was to fail to comply with bond.
Yeah, and I know that is a practice in some counties. It's just not been part of the culture here in Dane County. And frankly, I think the bail I've set is the very least amount of cash bail that would be necessary to assure appearance in court. I think I'm going to keep it at that. She's certainly free to ask for that to be reviewed by a judge later on.
Thanks, I appreciate it.
Yeah, no problem. We'll accept the waiver of the time limits. I wonder if just to keep things a little bit on track, we should. Well, I was going to talk about trying to schedule it for a status conference at the same time as the co-defendant. I'm just not sure that's possible.
The co-defendants is scheduled for June 15th, 40. I intended to do the setup at the same time.
Well, that's fine.
That works for the defense.
Great. So we'll get you some paperwork here in the next room. I hope things go well for you with your health as well as that of your family members. I did listen to what he said about that. I feel for you on that, but it doesn't change what had to be done.
All right, congratulations.
Take care, Josh. Yeah. Safe travels.
Next is Rebecca Lewis. Let's do it. Big one. Yeah, no, check it. This is a good route. This one's charging you with all down some big jumping.
Let's call the case of the state of Wisconsin versus Rebecca Lewick. It's case 26 CM 1075. Appearances, please.
Jack Schneider for the state.
Ms. Rebecca Lewick appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Ms. Lewick's complaint. I do waive its formal reading, reserve objections for a later court date. Ms. Lewick informs me that the address on the complaint is correct. I also have indicated to me that she is eligible for the services of the Public Defender's Office. Finally, I'd ask the court to enter not guilty pleas to each of the misdemeanor counts.
Okay. Thank you. We'll get the case assigned to Judge White, and that's because she does have her 4 other misdemeanor cases there. This is a misdemeanor case too, but the point is, we'll get it assigned to that judge. What's the state's position regarding bail?
Thank you, Your Honor. The state would request $500 cash bail for Ms. Lewick with the non-monetary conditions that she have no contact with David P. And that she be banned from the 5700 block of Raymond Road. As the court mentioned, this is Ms. Lewick's 5th open case. And again, it is alleged to be violating her bail conditions. It is my understanding that the victim in this matter allowed law enforcement to walk through the apartment with a property manager as a 30-day notice is being issued at that residence, where they find Ms. Lewick hiding in a closet with a box over her head. So from the state's perspective, the clear violation of that bail condition, I just think some cash is appropriate here.
Thank you, Mr. Bojo.
Sure. I just want to make sure I'm not missing anything. Is there a public safety assessment for one like?
I do not see one, and I think that may be because these are standalone bail jumping charges. I think one of their criteria is not to complete those when there are no substantive offenses other than the bail jumping.
Okay, thank you. He's saying substantive, meaning it's only the violation of the court order. There wasn't a separate crime associated. Okay. All right. So first of all, I'm just going to start with the basics. She does live in the area. She's been in Dane County for 15 years. She's got parents, siblings, friends, grown-up children in the area. She is currently, is receiving Badger Care as well as food stamp program. And so financially it would be difficult, if not impossible, for her to meet a cash bond from the state. She's also been eligible for the services of the Public Defender's Office. She has been appointed Attorney Richard Burris. So I guess what I would want to bring up is it appears from the complaint that there is, hold on. Okay, I mean, when was it available? Okay. I will note that, the allegations in the complaint, as the court has already pointed out, doesn't involve any additional substantive kind of crimes other than the bail jumping. I'm not minimizing the crimes charged, but I do think that it is important to note. It also seems like there's kind of some cooperative, contact here, or, consensual contact, with the person that she's not supposed to be having contact with based on the allegations. Finally, although I don't think it's necessarily a factor in the charges that are alleged here, Ms. Lewick informs me that she is scheduled to have a bed available for her on Friday at 5 Door Recovery to address some substance abuse issues. So for those reasons, I'd ask the court to consider a signature bond. I didn't hear about a missed court date in the past, or at least unless I missed that, and I don't have a PSA to kind of confirm or deny whether or not she's missed court in the past.
I did not hear a citation to any missed court dates. Any response from the state?
No, Your Honor.
Okay, well, we're on case number 5. All of the pending cases are either Act 3 eligible battery cases or specific bail violation type cases. I recognize that what's alleged in this complaint isn't itself Act 3 eligible. That is, bail jumping is not itself an Act 3 eligible offense or inherently assaultive or violent in nature. Of course, the law'd be a donkey if I couldn't take into account an allegation of a violation of a specific condition of bond involving no contact imposed in cases that are Act 3 eligible violent type offenses. And I do take that into account. I also have to take into account the fact that the system has in her pending cases attempted various levels of cash bails. She's posted those cash bails. There were attempts at pretrial services that were I'll use the term eventful. Here we are with a new allegation. I do respect and appreciate that this new allegation does not involve violent behavior. The hiding in a closet with a box overhead is, not obstructive in the sense that I would use that as a significant bail factor. But it is an indication that there's an awareness that she wasn't supposed to be there at a minimum. So I just don't see how we not set cash bail in an amount greater than she's posted previously here. I'm going to grant the state's request. I'll set cash bail at $500. I'll order that she not have contact with David P. and that she not be in the 5700 block of Raymond Road. I know there is this pretrial services history. It's just not an available option to me at this point either, because they're not taking new referrals. And honestly, I don't know that it's been all that effective in Ms. Lewick's cases here in the past. Let's get it scheduled for further proceedings. Ms. Lewick, you do have the right to ask for Judge White to review this bond. I know you've done that with bonds set by other commissioners in the past and with some success, and that's your right. You should talk to Mr. Burris about that. Good luck to you.
Next is Samuel Holt, appearing via Zoom. I was informed by the bailiff that the full slot was going to remain closed due to safety issues.
Okay, thank you. Well, why don't we call the case of the state versus Samuel Holt? It's case 26 CM 1073. Appearances, please.
Jack Schneider for the state.
Mr. Samuel Holt appears via Zoom video teleconference from the Dane County Jail, along with counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Mr. Holt's complaint. I do waive its formal reading and I reserve objections to a later court date. This is typically where I would ask to confirm the address of 1105 South Thompson Drive. Are we able to do that? Is he able to hear that or like give a thumbs up or something like that?
Mr. Holt, is your address 1105 South Thompson Drive? Is that your address? What's that? He stated he doesn't live there.
Okay. Is there a better address we can use?
What's a better address? You know the address?
Deputy, I was not able to hear his response. If you have an ability to interpret it for us, that would be great.
He was giving an address and then started laughing.
Okay. And just to set the scene, I know prior to going on the record, deputies indicated that, well, I can't remember how it was phrased, that maybe he didn't wish to participate. I do see him at the window now. That's good. That's right. Mr. Holt, if you speak up kind of loud, we should be able to hear you. Let me confirm you can hear us okay. Mr. Holt, can you hear us? All right, now it looks like the slot has been opened. That'll hopefully help in terms of being able to hear. Mr. Holt, are you able to hear us?
Yeah.
Okay, great. Yeah, can you give us that updated address for you?
Update? No, I'm saying my address is the same address type shit, bro.
The one on South Thompson Drive?
Yeah.
Okay, great.
All right. So I'll note that the address in the complaint is correct. I do not have an eligibility determination. It appears that Mr. Holt may not want a public defender. Mr. Holt, I'm going to have the deputy give you a form to either apply for or have some instructions on there if you change your mind. If it's okay with you, I can represent you just for today's hearing to try to get you out of jail, if that's all right.
Does that work with you, Mr. Holt? And Deputy, maybe you can confirm that that question came through on your side of the audio?
Yes, it did, Your Honor.
Okay, and it sounds like Mr. Holt just isn't answering.
I'll just appear on his behalf as a friend of the court today unless he determines he doesn't want me to. That's okay with Your Honor.
I think that's perfect. Thank you for doing that.
Yeah, no problem.
Yep, and I do see that he's now returned to his bunk, but he's still in a position where he should be able to hear and could participate if he chose to do so. State of a position regarding bail on this case that we're going to assign to Judge White.
Thank you, Your Honor. At this time, the state would request $500 cash bail, as well as the non-monetary conditions that he have no contact with Trevor K, as well as be banned from the State Street and Langdon area. It looks as though Mr. Holt was released on May 6th with a condition to be banned from the 600 block of State Street. That's an lewd and lascivious, disorderly conduct and resisting matter. His bail includes only not being on that block. Here, he's on that block, allegedly throwing punches at staff of State Street Brats. So given the disregard within days of those quite simple bail conditions, I think some cash bail is appropriate.
Mr. Boggio?
Sure. So first thing I'll note that I am in receipt of a Dane County Public Safety Assessment. It is recommending a signature bond. It discusses that he has very little history, it appears. I mean, no felony convictions or prior convictions at all. I understand that he was on bond, hence the bail jumping charge in this case, but it also appears that he has no failures to appear in the past. I would note that it looks like, I mean, the substantive charge here is a disorderly conduct. He has, so it is not an Act 3 eligible offense. So based on his history or lack of history missing court, I would ask the court to go along with the evidence-based tool and provide him with a signature bond at this time. Certainly, the additional charges may not help his ability to get a resolution, but I'm not sure it's an indication that he's just not going to show up in court. I don't have any objection to the non-monetary conditions requested by the state.
All right, I'm interested in any responsive arguments from the state. I guess one of the things and I don't know which way it cuts, but I know he had a couple of cases earlier this year.
That's my understanding, Your Honor. It looks like $1,000 cash bail was set in November of 2025. It looks as though he sat in the Dane County Jail. Competency was raised. The court in Branch 11, I believe, found Mr. Holt competent, and it was eventually blotted after I believe he had credit approaching time served at the end of April. So he was released on April 29th, has picked up 2 new criminal cases in the meantime. So I do think that given that history, cash bail is reasonable here.
And I think this is consistent with what you said, but it looks like after contested competency proceedings, the cases were resolved as one county ordinance violation with 5 other charges and 2 separate cases being dismissed.
That's my understanding.
Okay. And Mr. Boggio, anything else that you wanted to add?
I don't have any response, I'm sorry.
My math says the bail might have been $500. I think he had a signature bond in one case and 500 in the other, but
My notes indicate $1,000. That could be a typo, Your Honor.
well, and let me make sure. Yeah, I think it was a signature bond in the first of the 2 cases and then a $500 cash bail in the other. Ultimately, I guess I have to figure out what the right response is here, and it's not an easy one. I think this defense makes a valid point that this is not an Act 3 eligible offense. My primary consideration is supposed to be whether he's likely to appear in court. I don't have a demonstrated history of missing court appearances. I'm concerned about the alleged bail violations and him picking up a couple of charges in a relatively short time period. For better or for worse, doesn't look like he went far. He's alleged to have been literally blocks from the courthouse. I also probably have to take into account that when faced with really very similar allegations recently, they were resolved without any criminal convictions at all. That suggests that the risk of pretrial detention on a cash bail where the outcome may well be similar maybe isn't as appropriate as it could be if there was a likelihood of active criminal prosecution here. I say that, I'm having trouble reconciling it all. I think I'm gonna do that in favor of setting a cash bail, but setting it at a lesser amount than that proposed by the state. I'll set it at $300. I'll order as conditions that he have no contact with Trevor K. and that he not be in the State and Langdon ban area. We'll give him a map that contains the entirety of that area. It is bigger than the 600 block of State Street, which was his earlier condition in the earlier case. Of course, that is also alleged to be where the new case got picked up. We'll get a not guilty plea entered and get it scheduled at the same time as his other case. Mr. Holt, hope things improve for you.
Next is Christopher Rose for forfeiture. Christopher Rose. Yeah. Everyone will be safe as long as you got a decent, here you go, paperwork, sir. Please stand elected. Be patient. Okay.
There you go. Well, let's call the case of Dane County versus Christopher Rose, case 26 FO 839. Appearances, please.
Jack Schneider for the county. Christopher Rose in person, in custody without counsel, is also present.
All right, so yeah, Mr. Rose, looks like the DA decided not to charge you with a criminal offense. Yeah, so what you have there is a complaint that alleges a forfeiture. It's kind of a fancy way of saying that it's a non-criminal. Well, I don't know about that one way or the other. I don't have opinions on that, but it is a disorderly conduct charge as a non-criminal charge. It's like a ticket. You can enter a not guilty plea to that. If you do, we're letting you out of jail today. You won't have to post a bail. We just give you other court dates and you'd have the right to a trial on it. Or if you wanted to resolve it today, they probably have some offer for a fine to do that.
Not guilty.
Sounds fine. We'll get a not guilty plea entered for you. Is this address on Olin the best one to use?
Correct.
Okay. One other thing I need to talk with you about. You have the right to a trial on that charge. And you have the right, I'm sorry.
Disorderly conduct.
No, you do.
The trial.
You'd have the right to it, and I want to make sure you're aware of it.
Gotcha.
Yep, you also would have the right to have a 6-person jury decide that case. In order to get that, you have to pay $36 in jury fees in the next 10 days. If you don't pay the $36, you're not in trouble for that. You still get a trial. It's just that it's a judge that would decide rather than a jury. But you're all set for today, Mr. Rose. Take care. You too. Take care.
Next, Andrew Patel, military.
All right, let's call the cases of the state versus Alexandru Militaru, cases 26 CF 1062 and 1063. Appearances, please.
Jack Schneider for the state.
Stuff that can be out to that your bail could be stuff that where was that at? 42, 41.
Is that in Madison? What's the zip on that? Okay. Okay, so we're just. Got it. Mr. Alexandru, how do you say your last name?
Militaro.
Militaro. Mr. Militaro appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Mr. Militaro's complaints. I do waive their formal reading, reserve objections for a later court date. Mr. Militaro does not have a listed address on the complaints. I do have an address that he can receive mail at. That is 4201 Mandarin, Mandrin, Crescent Lane in Madison, Wisconsin, 53717.
I wonder if that's Mandan, Mandan instead of Mandarin. You know?
I cannot tell you 100% sure because I was kind of out surfing before this happened.
Sure.
Staying on my friend's house, but I think you might be right.
Okay.
I think you might be.
And I can't even tell you where it is, but I know I've heard that name of a street before. It's the Crescent part that makes it stand out a little bit.
Yeah, I think you might be right.
Yeah, but the clerk will look on Google and figure it out.
Fair enough. And he is eligible for the services of the Public Defender's Office. He has actually been appointed Attorney Zawada on his other cases. I'd ask the court to enter not guilty pleas to each of the misdemeanor counts.
Sure, we'll do that. He does have the open felony case assigned to Judge McNamara. We'll get these cases assigned to that same judge. State of a position regarding bail?
Thank you, Your Honor. In 1062, the state is requesting $2,500 cash bail, as well as the non-monetary conditions that Mr. Militaru have no contact with JAB, that he be banned from the 6100 block of Strathmore Lane in Madison. The state would also be requesting pretrial services for GPS monitoring at this time. I'm aware of the limitations of pretrial service currently, but I do think this is a case where it's appropriate. In 1063, the state is requesting $5,000 cash bail with the same non-monetary conditions. Mr. Militaru is on bail in a domestic violence case, a strangulation. And according to the teenage son of the victim in that strangulation, Mr. Militaru has been living at that address with the victim since his release. It looks like the officers made contact with him multiple times and receive calls that Mr. Militaru is at that home regularly. And each time they explain to him the terms of his bond, as well as the injunction order issued by Judge Highland, and he continues to flout orders of the court. During the last arrest, it looks like he was bold enough to tell the victim and her sons that he'll be back soon before leaving with officers. There seems to be zero indication that he will abide by court orders regarding contact with the alleged victim and her home. I will also note, according to the detective in this matter, I have a note from today that Mr. Militaru has called the victim 16 times from jail, asking about what she told police and asking her to call the DA to drop the charges.
Since the most recent arrest or previously?
I have a note, so I believe it's in a note in 1062. It's a note from today, approximately 2 hours ago. So it's my understanding that that's a recent report that he has been contacting her from the Dane County Jail. So from the state's perspective, Mr. Militaru is hell-bent on having contact with this victim and attempting to persuade her into changing her statement. So I do think that significant cash bail is appropriate here.
All right, thank you. Mr. Boggio.
You have a public safety assessment, and it does appear that it is requesting or recommending cash bond. I would ask the court to consider cash bond and $200 for each of the cases. Mr. Militaru was, I believe, $200 cash bond was what was ordered in the other case. So I'm not asking the court to go backward and provide some additional financial incentive for him to appear in court. It appears that he has only one missed court date in the past 2 years. Just a quick glance at the CCAP record for Mr. Militaru. We're not going to talk about that. Right, yeah. It appears that, there is one other closed case. So he has a limited history, but certainly a history that would allow the opportunity to miss court. I mean, if he only has one missed court date, that's at least somewhat of a track record of him appearing in court. He does not have prior violent convictions as well. I would certainly encourage the court to consider pretrial services. They have the ability to use GPS electronic monitoring as requested by the public safety assessment. I'm unaware of the current status of pretrial services. I'm sure the court is doing these hearings more often than I am would know if they are currently taking new applicants or not. I know that there was a pause for at least a while related to remote breath testing. I don't know if that extended to GPS as well.
I'm happy to state these corrected by anybody, but my recollection is that they're not currently taking referrals involving any form of active monitoring.
Understood. So I would ask that if the court is going to impose a higher cash bond, we would ask for it to be set for a timely prelim so that that could be reviewed at a time maybe that pretrial services is going to possibly be taking more applicants. I don't know where their wait list would be at. Last time I checked, I think it was about 2 weeks ago.
I don't think I have a lot of viable choices here.
May I add something, Your Honor? I failed to neglect that the underlying strangulation was charged as domestic abuse repeater. Those are 4 convictions involving the same victim, which he was on probation for at the time of that offense.
Okay. For FOR, not for the number. I get it.
Correct.
Okay. Well, I think that is directly relevant. My understanding is that Mr. Militaru was on probation supervision for those offenses, got revoked due to timing, I assume, based on the allegations in 26 CF 55. That would have been a 60-day imposed and stayed sentence that would have gone into effect. The judgment of conviction in that case, by that, I should say, case 23 CM 1970 says he had 7 days of credit, which suggests that he would have only finished his sentence really not too long ago, probably within the last month or month and a half or so. And now we have these new allegations. They're Act 3 eligible. They involve direct violations of court orders, and there's an allegation of intimidation. The state describes certain of the behaviors as, I think the term was bold. I don't remember if that was the exact phrase, but it was something along those lines, and I think it's apt. It's completely mind-blowing to me that he would ask to be able to have sort of a goodbye hug or contact with the kids. The law enforcement would allow that, and in their presence, he would then go and have contact with this person. I think I used the term mind-blowing. I'm going to use it again because I frankly don't have better words. It's plain that at this point, some sort of substantial cash bail is necessary to achieve partially appearance in court, but I think more importantly, to achieve the various goals under Act 3. I'm mindful of the fact that he was only required to post a relatively small bail in the earlier case. And, I try to have there be some escalation, but not necessarily an extraordinary escalation when I'm setting bail amounts. I also don't know that when that bail was set, anyone would have envisioned what's alleged in these various complaints and in terms of the, again, boldness of some of the alleged behaviors. Pretrial services would be a great option if it were an option. It's not. I recognize the state's request that I put him on the wait list. I guess I just think that's fictional at this point. It's not an available option. There won't be active monitoring for the immediate or foreseeable future. And I think I have to set a bail recognizing that. It also means that when that becomes an option, it's a pretty viable request to have that be considered and perhaps considered in exchange for some sort of a modification of the bond or as part of that. I'm not going to go quite as high as what the state requested, though I frankly don't think it's inappropriate. I'm going to set cash bail at $2,500 on each case. I will order as the conditions that he have no contact with JAB and that he not be in the 6100 block of Strathmore Lane. If this were sort of incidental or benign contact, I think we'd be talking about a relatively small escalation from the amount posted earlier. That's just not what's alleged here. It's alleged to be frequent, repeated, and out of a concerted effort to engage in what the statute calls as witness intimidation. So I have to take that seriously, and unfortunately for Mr. Miltaro. Let's get not guilty pleas entered on his behalf to the misdemeanor charges. Let's get it scheduled, the case is scheduled for prelim, within the time limits. I'm assuming that's the defense request.
Yes, please, Your Honor.
That's fair. Let's get that scheduled. Good luck to you, Mr. Militaro.
Right, just turn. Next is Javarius McAbee. Right, McAbee.
My name's Scott. Here's the truth. It's okay. So I just want to double check with you real quick. So this is the charge. They have, it doesn't look like there's an address on here. Joint issues to make up, it's a ground old. Any like word of what's going on with that whole they like what you meant with all. Oh, okay. Okay, all right, fair enough. Maybe it's been figured out. Never had it existing. It's so it's based on this whole case doesn't have to actually be the same charge. It's just where you have a prior class. Yeah, that qualifies for the repeater, but that oftentimes gets dismissed if you resolve the case, but we're gonna talk about it a second, okay?
Yes.
Yep, absolutely. Mr.
Did I call the case? I'm not sure if I did.
I'm sorry.
I forgot myself. That's okay. Let's call the case of the state versus Javarius McAbee, case 26 CM 1063. Appearances, please.
Jack Schneider for the state.
Mr. Javarius McAbee appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Mr. McAbee's complaint. I waive its formal reading, reserve objections for a later court date. Mr. McAbee does not have a listed address on the complaint. For the time being, let's just have the mail sent to the Dane County Jail as he is on a probation hold at the time or at this time. And I'd ask he is eligible for the services of the Public Defender's Office, and I'd ask the court to enter a not guilty plea to the sole count in the complaint.
Okay. Consistent with that, he is on that absconder warrant that's described in the complaint. It looks like that stemmed from convictions in branch 2. So we'll get this case assigned to Judge Kondar as well. What's the state's position regarding bail?
Thank you, Your Honor. At this time, the state is asking for $1,000 cash bail. It appears as though Mr. McAbee was released from prison on, I believe, February 5th. He had been absconding from supervision since February 15th. So 10 days later, until the time of this incident where he is alleged to essentially just run from law enforcement after police spot him and attempt to serve that warrant. So given the behavior alleged and the history of just being released from prison, I do think that cash bail is appropriate.
Mr. Boggio.
Sure. So Mr. McAbee's been in jail for 2 weeks now on an obstructing charge. I understand there is the repeater, which does give the additional exposure. However, he's basically a quarter of a way to the point where he'd have to be released or given a signature bond at least if he were to file a speedy trial demand. I think his bigger issue is probably the probation issue, and what he tells me is not conclusive on whether or not they're going to be seeking revocation or not. However, if they do decide to do a sanction, an ATR, or just drop the revocation matter, I wouldn't want this to be an obstructing charge that he possibly could be at time served at this point be what keeps him in custody. So for all those reasons, certainly he has an incentive to appear and would not likely get a bunch more time on an obstruction charge. So I'd ask the court consider a signature bond, also knowing that the appeal hold is in place.
Sure. And I guess I want to be clear, is that an oral speedy trial demand?
Sure.
All right.
Yeah.
We'll have the clerk note that so that hopefully Judge Kondar can get this put on for trial right away. I think that's Mr. McAbee's right. In the meantime, I do see a $500 cash bail as both necessary and appropriate. he's alleged to be an absconder with a prior conviction for, of all things, bail jumping, and then there's the flight from law enforcement. So I can't see this as a signature bond case. I don't know that it has to be $1,000 either. Let's get a not guilty plea entered on his behalf. We'll get him another court date here in the next room for now, though that might change depending on what happens with the judge receiving that speedy trial demand. Take care, Mr. McAfee.
And we'll get this appointed soon, okay?
Next, Jeffrey Hoffman.
I can make a note on here. She says she got requested and she. Okay, well then, if she's already requested, then, you know, my boss is probably taking care of that, but I'll make a note on here just to make sure. Thank you. Yeah, no problem.
Thank you, guys.
Yeah, good luck to you.
I'm sorry, who was the next name?
Hoffman.
Thank you. Appreciate it.
Wasn't listening either. Missed it.
Mr. Hoffman, my name is Sky Bojan. I'm here to just represent you on today's case. Looks like you got this one, which is the older case. And then sorry. You got this one, which is the one that's just recent. Looks like you're on appeal also. I just don't make a deal to address that today. I mean, you would. Yeah, I mean, I guess it is, I mean, it is your right. I mean, I typically say you don't want to talk with your attorney first and do it at that point, but if you do it right. Okay. Did you call the case? I'm
No,
sorry.
I don't remember again. It's getting to be the end of a day. Let's call the cases of the state versus Jeffrey Hoffman. Their cases 25 CM 2618 and 26 CM 1072. Appearances, please.
Jack Schneider for the state.
Mr. Jeffrey Hoffman appears in person and in custody alongside counsel Skylar Bojo from the Public Defender's Office. I have received a copy of his complaints. I do waive their formal reading, and I do reserve objections for a later court date. Still good address. Yeah. The address on the complaint, just want to make sure they're the same. Yes. The address on the complaints are correct. Mr. Hoffman is eligible for the services of the Public Defender's Office. I'd ask the court to enter not guilty pleas to each of the misdemeanor counts. And Mr. Hoffman is requesting to assert his right to a speedy trial at this time as well.
Okay, and should we list that in both cases?
Yes, please.
All right. And just to set the scene a little bit, it appears that Mr. Hoffman is in custody on a probation hold from some earlier cases. In 25 CM 2618, we're here on return of a bench warrant that was issued back in February. That case is assigned to Judge White. And then that means that the new case, which is case number 26 CM 1072, also needs to be assigned to Judge White. Let's take up the state's position regarding bail.
Your Honor, in the return on warrant case, the state would be requesting $250 cash bail given the missed court appearance. And in 26 CM 1072, the state would be requesting $500 cash bail, as well as the non-monetary conditions that Mr. Hoffman not operate a motor vehicle without a valid driver's license. Obviously, the warrant was active at the time of this offense, and given the missed court appearance and the allegations of additional crime while on bail, I do think some cash bail is appropriate.
Just because I'm sure we'll talk about the conditions shortly, is there a reason to think that the alleged behavior relates to license status as opposed to the other warrants, for example?
I would defer to the court.
Well, I don't know either. That's why I'm asking. But Mr. Boggio, any position?
Well, I'm going to ask for a signature bond because he is on a probation hold and I'm unaware of the status of, you know, his either revocation or non-revocation matter. But certainly he's on a hold and I don't like to tie up agents' hands and not allow them to do an ATR because an individual can't post $750 of cash bond. He is on Badger Care and Food Share. He has worked construction in the past, but is not employed currently. Has 2 children in the area, and has lived in Wisconsin for his entire life. Being that he's been in custody for, you know, some time on this, I think that does, you know, give him less incentive to flee. So I would ask that the court consider signature bonds in each of these cases.
I see the state's requests as being really quite reasonable. I'll set cash bail at $250 in the earlier warrant return case. That's a disorderly conduct charge, so smaller in the big scheme of things, but though he's charged as a repeater there. And then we have the new case where there's an allegation of an effort to flee on a bike and then some resistive behavior following that. I'll set $500 there. I'm going to make the condition in that case be that he simply not operate a motor vehicle. It's whether one looks at it from sort of an eluding like perspective or one looks at it from the fugitive perspective, it involves an allegation of the use of a vehicle for flight, and we shouldn't have that. So we'll make that condition be put in place. Let's get a not guilty plea entered for Mr. Hoffman. You know, he makes the point about your agent could lift the hold. That's true. That could happen. There's also always the ability to have these bails reviewed. You've made the speedy trial demand that hopefully it'll get things moving a little faster for you too. Good luck to you, Mr. Hoffman. Take care.
Next is Gregory Wallace.
Was an all.
I don't actually schedule these, so it's.
Okay. But you just wanted.
Gregory Wallace. Those are contagious.
It was.
Mr. Wallace, just a quick question for you. First of all, is this a correct address? One up here. Is it a correct address? Okay, let's update it because we're gonna have to update it for the court.
202 Shore Road.
It is,
Transportation told me that the AR would do.
looks like they decided otherwise. It's certainly something that can be fought on a different day, but today I'm just trying to get you out of jail. What's the zip code on the Schrader Road address?
Oh, it's 202 Cottage Road.
Oh, Cottage Grove, I'm sorry, I thought you said Schrader Road. What's the zip on that?
5376.
It is in Madison, right? 53 what?
706.
Thank you. Okay. Mr. Gregory, oh, sorry, we haven't called the case. All right.
It happens. Let's call the case of the state versus Gregory Wallace. It's case 26 CF 1064. Appearances, please.
Jack Schneider for the state.
Mr. Gregory Wallace appears in person and in custody alongside counsel Skylar Bojo from the Public Defender's Office. I have received a copy of Mr. Wallace's complaint. I do waive its formal reading, reserve objections for a later court date. Mr. Wallace indicated to me that the address on the complaint is not correct. It should actually be 202 Cottage Grove Road in Madison, Wisconsin, 53716. I do not have an eligibility determination for Mr. Wallace. I do have the public defender form, should you decide to apply. Otherwise, I would, if you do not qualify or decide to hire your own attorney, I would recommend doing that as soon as possible. And I would ask the court to enter not guilty pleas to counts 1 and 2, the misdemeanor counts in the complaint.
All right, very good. So it looks like Mr. Wallace has 5 other open cases, 2 felonies, 3 misdemeanors. They're all assigned to Judge Highland. One of those cases is one for which a cash bail was set yesterday by Commissioner Osmus. So what's alleged in this complaint is from before that. It's not something that's alleged to have happened since then. What's the state's position regarding bail?
Your Honor, at this time, the state is requesting $20,000 cash bail for Mr. Wallace with the non-monetary conditions that he have no contact with Draco, that's DREYCO, last initial W, or Leo, LEO, last initial W, and that he direct no acts or threats of violence toward Tantanita, TANTYNITA, last initial C. Mr. Wallace has a atrocious history showing up for court as well as complying with lawful orders. Here it is alleged that law enforcement are called after an argument between Mr. Wallace and his partner. Mr. Wallace refused to come out of the bathroom. His partner lets law enforcement know that Mr. Wallace has a warrant. He then comes out of the bathroom enters the bedroom where there are 3 small children, including a child victim. He then gives a fake name to law enforcement. They are able to correct that information, attempt to make an arrest. Mr. Wallace then says he wants to hug his child and quickly picks up that child, starts backing away towards the closet, which also leads into a bathroom. And with child victim in his arms, Mr. Wallace enters the closet with other children and then uses child victim as a shield between himself and police, and is using both his and child victim's bodies to push against the door in an attempt to barricade himself inside. So,
Wow.
hold on. In addition to that, Mr. Wallace also barricaded himself in a room with children to avoid arrest in 25 CF 1505. There were trial dates set in that matter in October of 2025. Prior to those trial dates, Mr. Wallace cut off his GPS bracelet, missed court on September 11th of 2025, and has been on warrant status since. This behavior.
I usually do make a habit of noting this at the beginning, and I failed to do that. He is in custody on body-only warrants and a variety of other cases. He's scheduled for a bail hearing in front of the judge on those in about a week or so. Sorry, counsel, go ahead.
Understood. And this behavior came after the defendant posted cash bail in his open cases. And one of those times that cash bail was posted, that was on a stolen credit card. So the state has absolutely no faith that Mr. Wallace will appear for court, given his history, without significant cash bail on the line.
And I think you gave a case number for it, but did you indicate there was a prior sort of barricade, human shield type situation?
25 CF 1505.
Okay. And the complaint does seem to allege similar sort of behavior in this complaint, but if I'm not mistaken, it's charged as 2 counts of disorderly conduct.
There's also count 3, I believe, Your Honor.
True, the resisting.
Yeah.
Okay. Anything else before I hear from the defense?
No.
I missed the number. I'm sorry. Was there? What
I
was
think the
that?
request was 20 grand.
20. Thank you.
That's right, isn't it?
Correct.
Yeah, okay.
Okay. So Mr. Wallace has a address to go to, received mail out in the area. He obviously has ties with his family, his kids. I would ask the court to make some exceptions for contact with his children. Even if it is, like either in public place or with somebody else present or some other, safety provision to add to that, but to cut off his contact with his kids, I think might be an extreme measure. It might go beyond what's necessary under the 969 statute. I'm gonna kind of withhold the rest arguments at this time, but I think certainly a lower cash bond is appropriate. I don't know what has been imposed in the past, but I'm certainly asking for something far lower than what the state is asking. The $20,000 will almost certainly hold Mr. Wallace at this time.
And I guess I'm trying to figure out how some of the pieces fit together. I know the state requested no contact conditions with 2 individuals with the last name W. Are those the children that are
Yes.
subject to those allegations? Okay. Right, yeah, that's what I'm gathering here.
That's the, nobody helps me with nothing.
Okay, well. Basically, everything alleged in this complaint is concerning, and it would be concerning even if it wasn't the fact that at the time he was already essentially an absconder or in the wind as a result of these various other charges. The state appears to have been fairly generous in terms of the charges that were issued, and I mean that he's charged with 2 counts of disorderly conduct and 1 count of felony resisting, as opposed to any specific child-related counts. There's no bail jumping allegations, despite the fact that that certainly would have been an available option. It's concerning that there were cash bails set and sort of posted in those earlier cases. I say it that way because of the indication that at least one of them or more was perhaps under fraudulent circumstances. I mean, there was a finding made by a judge regarding that, so I should rely on that finding. I think if the more serious charges that might apply were issued in this complaint, the $20,000 would be a very reasonable number, and it might be on the small side. That isn't what we have. We have him faced with these particular charges. It still requires a substantial cash bail, but less. I'll set cash bail here at $10,000. I am going to order that the jail is not permitted to release him from the jail unless that is posted in United States currency that is specifically in the form of cash, for I think obvious reasons. I'll adopt the non-monetary conditions that were proposed. I am concerned about what he says about his kids and their well-being and contact and all of that. I also have to be concerned about his kids from the perspective of what's alleged in this complaint, as well as the one in case 1505. I don't, perhaps there are two versions of Mr. Wallace depending on the circumstances, but at least one of them is pretty scary if what it says in this complaint is true. That's what we're going to find out. I don't know yet whether it's true, but I have to play things safe, particularly for the benefit of your kids. And I'm going to do that. So we'll get not guilty pleas enter for Mr. Wallace on the misdemeanor counts. Why don't we get the felony part scheduled for a prelim on May 19th at 1:30? He's already scheduled for prelim on the case from yesterday at that time. That gets him into court right away on those things and potentially can have bail reviewed as well. Good luck to you, Mr. Wallace. Take care.
Thank you, Your Honor.
One more question.
Yeah. So he put in the no contact order for now, but it can be reviewed at the next hearing.
Next is Tanner Hunt.
Stop writing this.
Mr. Hunt.
Hey, Tanner. My name's scheduled. So this is just here to represent today's case and try to get you out. Looks like you got. Looks like Andrew Shane or something like that. Turn. Yeah. Okay, so it looks like you're not eligible for both members of this. If anything changes, you can go to our office and call. But yeah. Yeah, better 1 second. So I'm gonna try and get that by Thursday. Okay, so it looks like you're charged to go ahead and buy second. Yeah, and then just the bill jumping here. That's the probably driving. Okay, and then I just want to double check. That's the better rest. Yeah, no, that's it. So I don't think I'm gonna. Okay. Got it. Okay, thank you.
All right, let's call the cases of the state versus Tanner Hunt. Their cases 26 CM 1074 and 26 CT 275. Appearances, please.
Jack Schneider for the state.
Mr. Tanner Hunt appears in person and in custody alongside counsel Skylar Boggio from the Public Defender's Office. I have received a copy of Mr. Hunt's complaints. I waive their formal reading, reserve objections for a later court date. There is an updated address, which should be 1734 Voigt Avenue, VOIGHT, apartment, is that 12? Oh, okay. Sorry, my notes are incorrect. It should be Boyd Avenue and apartment 12. Apartment R.
Like the letter R.
Yeah,
Okay.
yes.
Great.
And it's in Madison, Wisconsin, 53704. And I have indicated to me that he is not eligible for the services of the Public Defender's Office. It looks like on previous cases, Attorney Shaner and Attorney Bell are appointed. I have given him the Public Defender form just in case he does need to reapply or financial circumstances change. And finally, I'd ask the court to enter not guilty pleas to, I think, all counts in the complaints.
Sure, we can do that. applying at the public defender's office is an option. They're saying right now they think they maybe make too much money to qualify for that. That might be the situation you were in when you applied and got the other attorneys in your older case. You could follow that same process. Likely they'd get them on board for these two. That would be fine. That case is assigned to Judge.
Highland.
Thank you. We'll get these other cases assigned to the judge as well. I recognize that the OWI case 26 CT 275 alleges behavior that actually precedes that other case. The other case, not so much. What's the state's position regarding bail?
Thank you, Your Honor. The state in the 26 CT 275 manner is requesting $250 cash bail, as well as the non-monetary conditions that Mr. Hunt not use or possess any alcohol, and he not operate a motor vehicle. And in 26 CM 1074, the state is requesting $250 cash bail, as well as the non-monetary condition that Mr. Hunt not operate a motor vehicle. We do have the failure to appear. It looks like at the original initial appearance that was set on April 16th of 2026, I believe that was resolved when he showed up in his other OWI second case last week sometime, or maybe that was when he was put into custody. The timeline is a little confusing on that end, but he did miss that court appearance back in April, and then is alleged to be violating bail conditions from that original OWI second that was charged back in 2025 by operating a motor vehicle in the 26 CM 1074 case. So I do think some cash bail in a modest amount is appropriate here.
And Mr. Boggio.
Sure. I'm going to be asking for a signature bond. I just wanted to double check. Maybe the court has the information readily available. So it looks like we have the July 17, 2025 case. That one he was summoned in for and missed the initial appearance. Is that one?
So if you're referring to the criminal traffic case that's in
Yes.
front of us today,
Yes.
it looks like, well, there are citations on file. We'll put it that way, but this is also a case that likely involved a significant delay because of drug testing.
Right. That was my.
Oh,
yeah.
I'm open to suggestion from either party as to how much notice might have been provided for that or whether he received it.
And he just provided a new address, so I'm wondering if he was summoned but was sent to the wrong address. So I think there's at least maybe not a presumption, but a possibility that he did not receive notice for that case, and I'd ask that he receive a signature bond. As for the misdemeanor bail jumping, I mean, it's essentially a glorified OAR. Understanding that violating the court order does make that a more serious charge. I don't necessarily think it should result in additional cash bond in this case. He spent some time in jail for it. I think this is a matter that he can be expected to appear. He just has the one missed court date. It looks like he has gotten counsel, and that's, I think, a further indication that he has availed himself to court and wants to either get these matters resolved or fight them. That's certainly between him and Attorney Bell. The PSA that I am in receipt of does show no prior violent convictions and one failure to appear within the last 2 years. I'm wondering if it's been the one that we've been discussing. It does recommend a signature bond. It also does recommend complying with pretrial services. Unfortunately, that's not an option. Maybe appropriate in this case, but certainly not an option based on our previous conversation. So I'd ask the court to give him the benefit of the doubt, especially with the updated address, and give him signature bonds in both cases.
Your Honor, just to be clear, it looks like a citation was mailed based on my notes in January of this year.
To where?
I am trying to figure that part out.
I can't speak specifically to the mailing. The citation itself has an address on Lean Road.
On Lean Road?
I don't know.
Okay. Sounds like he no longer lives there or had to leave that place. It sounds like abruptly.
Okay. Well, and it's probably something to discuss since that is the address on file in the other open case, case 25 CT 596. Should the clerk be updating the address to the Boyd Avenue address in that case also then? So that's the same on all of it?
Just for that address.
That's where you're getting mail?
Yeah.
Okay.
Just so it's permanent so that.
Okay.
I don't miss any, cause that's why I thought I missed the other court date. But I even called my attorney. And she didn't know that I missed the court date either, for this one, because I don't think she's a lawyer for the,
For the other two.
for that one, yes. I
Understood.
called her and I was like, I gotta learn, she didn't know. for sure.
Yeah. Well, I get what you're saying. Anything else from either lawyer?
No, Your Honor.
No. In some ways, this case isn't all that different than the one we had earlier in the session where somebody had basically 3 driving offenses in relatively short order. I think there was a joint request for a signature bond and I ultimately went along with that. There are some differences. This case involves 2 pending operating under the influence charges, but neither of them are truly recent. They're all working on about a year ago, and that's probably got to do with, again, drug testing delays. I can't speak for certain to what happened with notice for Mr. Hunt in 26 CT 275. It's my experience that often when there's that drug testing, somebody is given a citation at the time of the initial appearance or at the time of the arrest that has a court date on it that really just doesn't happen because of significant delays in the testing. Then stuff gets mailed. It sounds like that might be the case here, but that also does make it plausible that he wouldn't have known about the court date and missed it not on purpose. Concerned about the fact that he's alleged to have more recently picked up this offense with the allegation of driving, despite there being the condition to not drive in the other open case. At the same time, he's actually not even charged with a traffic violation. At least in the criminal complaint for that. He's not charged with operating after revocation. He's not charged with any traffic related criminal charge despite that bail condition. There's just the bail condition violation itself. Other than perhaps some reluctance to probably want to get arrested on his warrant, Mr. Hunt seems like he was mostly cooperative with the police, acknowledged he had the warrant. Kind of wish if you'd have known you had the warrant, you would have dealt with it prior to getting arrested and getting picked up on new charges. The overall picture here is that this is probably a pretty workable signature bond case. I know that's inconsistent with the PSA, but I too infer that the PSA recommendation is based on the missed court appearance that, for the reasons I identified, I just don't put much weight on.
Your Honor, I think it is a signature bond recommendation.
Oh, I'm sorry.
Yeah.
Well,
I think
point. Then
it says with pretrial services. That's what, and I'm sorry if I confused.
Well, I don't know that you did. I think that was my mistake. All the better, because it means then that the release on a signature bond is consistent with that, despite it including a failure to appear that may just not be all that reliable for prediction purposes. Pretrial services would be, I think, a very good option if it were available. It's not. So I just can't do it. And this is not a case where I think that dictates then some cash bail. Let's try the signature bond. It's going to have to work a little better than it did in that other case, or we're not going to have any options here. But we'll do signature bonds in each case. I am going to have conditions in both cases be that he not operate a motor vehicle. In 275, we'll have there be a condition that he not consume any alcohol. It's against the law anyway to not use drugs, so you know that can't be a thing, but I won't set it as a specific additional condition. Let's get not guilty pleas entered for Mr. Hunt. We'll get this all scheduled. Well, the clerk will figure out scheduling. I don't know whether we're gonna set it or send it to the judge for scheduling, but we'll figure that out.
It'll be July 6th, 3 o'clock, same time as the other hearing.
Great. Okay, good luck to you, Mr. Hunt. I hope things work out.
Yeah, you take care, okay?
How's everyone today?